Mr. Smith.
Well, so we're going to move on to the judge's articulation of his approach. So we need to pick it up on page 466 of the bundle. See a big heading in the middle of that page, subsection E. It starts at paragraph 453. And he starts by saying that his objective is to articulate the appropriate price that an implementer should pay set owner holding a proportion of the stack of SEPs. And he goes on and says that it must be FRAND, says what that is. And what the judge is really doing here is stating he's basically going to assess the price of the whole stack and thereby derive the price that a SEP owner holding a proportion of the stack should be paid. And that last sentence of para 453 seems unobjectionable enough by simply stating it must be fair, reasonable and non-discriminatory. At least as regards to his stating that must be so as between implementers. So the price different implementers pay should be about the same. But my lords, look at the very next paragraph, 454. The judge says more specifically he's pricing the value to Apple of the portfolio. That's a rather peculiar thing to say if it's broadly the same for everyone. And of course that very point, approaching the issue as if it was an Apple-specific price, was the point we criticised Miss Guttridge for, and the judge dealt with earlier and identified as the very reason he was rejecting all our evidence. Now, 455, the judge says the only material has to ascertain the price, that's the price to Apple of the portfolio, is the Optis and Apple comparables. And he refers to the concern he has expressed about them, but says it's the best evidence he has, and so he must do the best he can. Again, pausing here, there's a peculiarity here. The judge has expressed his concern about comparables earlier, indeed rejecting comparables approach at a point in his judgment where he's not worried about what the alternative is. And now he's putting forward an alternative, and he says the comparables are the best evidence he has, even though he's worried about them. But as we shall see, he doesn't use them in the way that would conventionally be used when relying upon the comparables. And in fact, paragraph 455 goes on to say the judge is not going to allow the exercise to fail for want of data, and he's going to apply assumptions where necessary or broad brush or broad acts as appropriate. Can I just stop and make 2 points about this? First, as to the judge applying assumptions or approximations, the broad acts. There's a world of difference between the judge turning his mind to an issue and what, if any, assumption or approximation may be appropriate, and explaining it if there is some gap in the evidence and consciously adopting it. A world of difference between that compared to a situation where the judge doesn't do that, perhaps simply misunderstanding what he's doing or overlooking matters, and my friends coming along on this appeal to seek to argue that some assumption or approximation not consciously made by the judge could have been considered. It's a world of difference on that, and I'm going to point out where that arises as we go through the arguments, but I just want my lords to have that distinction in mind, because it's not good enough to say here's a reason that a broad act might have been a reason to do this, when the judge isn't actually explaining that he's filling in some gap in the evidence with an assumption at all. And the second point I make is to reiterate that we've not anywhere seen any consideration as to the assumptions and approximations that the judge is referring to that he's now going to have to apply, whether they're better or worse than those that the experts in their approach applied. Most specifically, those aspects of their approach that were common ground that I identified earlier. And I'll seek to identify the effect of what the judge does, often without even appearing to realise it, as I explain how this part of the judgment progresses, and how what he's doing is significantly worse than what the experts did, and as my lords appreciate, departing from key features that were common ground. Moving on, paragraph 456 explains generally what the judge has resolved to do, and that's price the entire stack to Apple So again, there's a focus on an Apple-specific price, and then apportion it pro rata amongst what he calls the co-owners in proportion to their holding, which he says he's going to do calculated by anography. And at 457, the judge says he's in broad terms following the Apple framework, although he's jettisoned key elements of the framework as unhelpful and wrong. He goes over the page and says it's an obvious course and formed part of the Optis top-down cross-check. And he said it would occur to him in any event. Now again, just pausing, my lords, what the top-down cross-check and the Apple framework have in common is that they utilise a notion of an overall stack price, but they don't value it in a way that remotely resembles what the judge does. Just to remind you, the Apple framework starts with the valuable price from an argument or calculation as to the profit on chipsets or mobile devices. And we had the conventional top-down cross-check using the price working backwards. So to the extent to which those two methods are being referred to by the judge as resembling what he's doing, it's simply that there is an overall stack price. In fact, perhaps the apple pie approach I explained earlier is a bit closer, and that's using the Apple licenses to assess how much of the stack Apple is licensed to under and what it pays for that. But there are also still very significant differences with both Apple and Optis's version of that exercise compared to what the judge does. So I just want to lay down that marker at this point. There really isn't much of a parallel to be drawn other than the fact that there is, as part of the exercise, this idea of the overall stack price. Now, the judge moves first to what he refers to as identifying the stack and the shares in the stack, and this is a section on page 238 of the judgment, so page 467 of the bundle, and the first three subparagraphs of 460 deal with the stack share of Optis, Apple and Apple licensed counterparties respectively. In the previous paragraph, 459, the judge has said he's going to use 26,600 as the size of the denominator to assess the stack, noting it's not the same as the figure used by Miss Guttridge, Apple's expert. Although, as we will see, he in fact never uses that number for Apple and Apple licensed counterparties, and having used it for Optis, he promptly changes to another number. Anyway, he says at this stage that that's what he's going to start by using, and he states that means the Optis share is 0.051, or if Ericsson patents are excluded, 0.31. He notes that in some Optis comparables, not the entire portfolio is licensed, but he says he doesn't propose to reduce it to that point. It's a point he refers back to in subparagraph 3, just above the table where he says he doesn't need to calculate the share for Optis counterparties. That's an obvious point because there's no cross-licensing. And he goes on and says he will use a single figure for Optis, which he suggests is generous to Optis. Can I just pause there? Because he seems to have got in another muddle on this, and that's as to the generosity of this point. Treating a sum payable for the whole portfolio, even if the licence was for a fraction of it, is generous to Apple, not Optis. If a given price was in fact being paid for only a fraction of the whole portfolio, that would obviously imply a greater price for the whole, or a greater price when scaled to 1% of the stack, not a lesser price. My criticism is not so much that this is what he decided to do, it's to point out he had no proper understanding of what's actually going on. In paragraph 460, little 2, the judge simply takes Miss Guttridge's assessment of Apple's share, 1.07, so he's not using his own denominator. And at para 460, little 3, is a table identifying the 9 Apple licenses, giving the share of the stack for each counterparty. They're also taken from Miss Guttridge, so not using the denominator he's chosen. My lords will see some of these are very significant. Huawei about 8.5%, Ericsson about half that. Nokia, this is the top of page 468, similar to Huawei. Qualcomm not that far behind. But many really are tiny. For example, the second entry in the table, Grand Mesa, 0.005%, 100 times smaller than Optis. And it would be even smaller if the same denominator, 26,600, had been used. Orange, Longhorn, KPN, all tiny too. Now, the judge points out in the text under the table on page 468 that the sum of these percentages shares is around 50%, but he's deliberately vague about that. He says it's not even a rounded total. The total is in fact somewhere between 51 and 52%. But as the judge points out, there is in fact some double counting, because I think there's 2 entry contracts in there. Now, subpara 4 on page 468 is where the judge actually says he's not going to use 26,600 but 22,000. So that leads to a recalculation of the Optis stack. This is the top of page 469, subparagraph 3. And the share using this smaller denominator on inography is 0.61% for the whole, or 0.38% excluding the Ericsson patent families. So that is the stack share measurement when using inography. The judge turns to the topic of getting a value for the stack at 462. And para 462 points out that he doesn't have data regarding every component element of the stack, and that's pointing out that licenses has been given are Apple and Optis' ones, and they obviously don't cover all the stack. But he says what he can do is consider as many components of the stack as he can, rendering them comparable or equivalent, and use those equivalent values to derive 100% value. We'll see what he means by rendering them comparable or equivalent soon. What's clear at this stage, though, is he wants to include as many components of the stack as he can, which in practice means the Optis component from an Optis license and other components from Apple licenses. The last sentence of 462 is worth noting, because the judge says that using multiple data sources, that obviously is a reference to multiple agreements, means that outliers or unrepresented cases can be averaged out and a safer, more reliable overfigure obtained. Can I just identify an unspoken assumption there? That is that the body of information he has is a set where they're equally likely to be outliers at either end and by the same amount, i.e. that there is no systematic skewing of the data across all or most of it. The idea that outliers cancel each other out only works if that is so. And to be absolutely clear with my lords as to why this matters, almost all of these agreements are Apple agreements, and my appeal on the issue of legitimate, illegitimate holdout bites here. If they have all or mostly been significantly depressed by conduct pursued routinely as a matter of policy by Apple, which the judge wrongly viewed as legitimate holdout, this idea that one gets a better overall figure by including more is obviously wrong. In fact, you get the opposite. The more agreements affected by this that you include, the further from true frand you get. And it's an important part of why our primary cases, that this exercise the judge has embarked on, can't stand at all. So that's the unspoken assumption there. The next paragraph, 463, starts by stating the stack can be valued at either a total ad valorem rate or a total lump sum rate. This is the judge in a muddle again, totally forgetting DPU, but treating lump sum as a rate. And the judge says that reflects the comparables that are available to him. And he says he's going to do both exercises and goes on to refer to the ability to do ad valorem on Optis comparables without unpacking, but the Apple comparables need to be unpacked. Now again in my submission he's immediately getting off on the wrong foot, completely forgetting about DPU as a way to consider valuation and still talking about this lump sum rate. At 464 he says the lump sum price for the stack is a total price payable for use of cellular standard irrespective of ASPs, that's average selling price, and volume sold by Apple. And he says it's mainly achieved through use of Apple comparables. The word mainly is important because it's not wholly. Now, that's quite an important paragraph here, because he's absolutely identifying that what he's doing is something that has got nothing to do with volume, nothing to do with sales of units.
He says a lump sum must be calculated by reference to the implementer seeking to license the portfolio in question, which the Optis comparables do not by definition do.
Yeah.
What on earth does that mean? Because the whole point about the Optis comparables is they are a license of the portfolio in question.
Well, the problem, my lord, is that he's got it completely the wrong way round. He thinks that what really matters is who the implementer is, and that the implementer should have a special price for the implementer. And he's not worried about what the portfolio is, because he says it must be calculated by reference to the implementer seeking the license to the portfolio.
Yeah, so the point is that there isn't, rightly or wrongly, what the judge is referring to, when he says the Apple comparables do not do, what they do not do is license Apple. So the Optis comparables, they will.
Yeah, exactly. Exactly.
The Optis comparables don't license Apple, which they clearly don't.
No.
And that's what's being referred to as
that's what's being referred to. They're not as good because, in his view, he wants to have a price for Apple.
But if there was a license between Optis and Apple, you wouldn't be in court in the first place.
Not me, my lord.
It's mad.
Well, my lord will see the additional points made in the footnote 599. He says the Optis counterparties, with the exception of Google, are far smaller than Apple, so would pay a lower lump sum rate in any rational market. Now, we really are in Alice in Wonderland here now, my lord, because he's already just said that it's going to be irrespective of units, but the footnote says that units matter. He says with the exception of Google. So the judge, as I understand it, is basically saying, with the exception of Google, all the other Optis licenses, if put in terms of a lump sum, would be for an implementer who has far smaller sales, and in any rational market they should be paying less.
But he doesn't merely mean less as a figure, he means less when scaled up, presumably.
No, I think he means overall less as a lump sum as well. Yeah, he means that if you work out, if you use the Optis comparables with smaller people and you've turned them into a lump sum, which he thinks you can do, and then you use those as part of your assessment, you'd be doing something wrong because they ought to have been paying a lower lump sum because they're selling far fewer units. That's I think what he's saying, which is contrary to the basic premise that he's introduced right at the beginning, that the lump sum price for the stack, irrespective of ASP and volume.
I wonder if the footnote doesn't, when it says smaller than Apple, since it says with the exception of Google, is it talking about units or is it talking about just economic size, strength?
Then it's not obvious that someone with less economic strength would pay less.
No,
True.
I have to say, I've never.
Non-discrimination might lead to the opposite.
Yeah, well, that's the further problem. I have to say, at that point, had never occurred to me. I think what he's really saying is that if I calculate a lump sum, ignoring units, there's a point where I get to dealing with people that are so small in the market that they, in any rational market, they ought to be paying less because they're selling fewer units. Now, there's a big problem because the line the judge seems to be drawing is somewhere between Google and these other Optis counterparties. He's clearly keeping Google as an exception to this. So Google will stay in, and they're obviously selling far, far fewer units than Apple, but that he's just content to use the Google license as a lump sum indicator. So certainly my understanding was the effect of what he's doing is saying those selling at levels of units somewhere between Google and these lower ones in any rational market would pay a lower lump sum for the stack. But those selling at Google levels, or whatever that unidentified position slightly below is, and above, including Apple levels, all pay the same lump sum that doesn't reflect volumes at all. That seems to be the thrust of what he's saying if you combine the introductory bit of 464 with the footnote. And my lords will perhaps understand my submission that this is just rationally insupportable. And when we get to it, it's the nub of my ground 8. Indeed, there's much more detail to this because Apple licenses are affected as between themselves by variations of units, quite significant variations. It's not just the changing Apple volumes over time that they are significant, but particularly when you take into account different volumes of units covered by cross-licensing. This error runs through all of those points. But what he's basically saying is that he's not going to be taking account of units sold in the his approach, save for he's going to exclude those very small Optis comparables, because in any rational market they should be paying less.
And footnote 598 bears on this too, does it?
It does at the end, you're quite right. It does at the end. Anyway, my lords, the point I'm just trying to emphasise as we go through the judgment is this is just a rather inconsistent, well, very inconsistent aspect of paragraph 464. Firstly, stating the lump sum shouldn't depend upon volumes, but in footnote 599 saying that it does in any rational market, at least for those much lower sales. What the judge moves to next, and this is his para 465, is table 9, which he sets out over the page. It's the detail of an ad valorem assessment, and for this he takes Mr. Besant's unpackings, both the free release and simple. He doesn't use the adjusted. And notably he says at the end of paragraph 6, at the top of 472, that he's satisfied Mr. Besant did reliable work and he's content to use those figures. Just pausing on that point. What that is a finding about is that the unpacking Mr. Besant did was reliable enough to use for ad valorem, and that, just so that you know, used PA in the treatment of the cross-licensing. So that, just that aspect where all you need is the ratio, as I pointed out earlier, you only need that. But use of PA is subject to that finding here. Now the agreements that are set out in Table 9 on page 471 are in chronological order, identifying Mr. Besant's ad valorem figures in column 4. And we also see the stack share for all of those other than Optis licenses taken from the earlier Table 8, which my lords will recall was from Miss Guttridge. So that used inography, and specifically the denominator of 21,098. Paragraph 465, little 7, begins by making perhaps an obvious point that where the licence itself is expressed in ad valorem terms, the free release and simple unpacking gives the same result. That applies to Optis licences other than Google. Perhaps might have been better expressed as you don't need to unpack it at all, but it's the explanation as to why the numbers are the same in some of the columns. Now, subparagraph 7 on 472 also goes on to explain that the difference for a lump sum licence as between simple and free release. The judge then says this, that the result is that the simple unpacking gives an ad valorem rate that is about half of the free release. Something the judge expresses a view is scarcely surprising, as he says most have a 5-year term and a 5-year release period or assumed release period. Can I just ask my lords to look at table 9 and glance down through the respective simple and free release numbers? I'm not going to read any out. There are certainly some of the Apple licenses where the free release is about double the simple unpacking. But if you look at the licenses with counterparties with significant shares of the stack, the judges, using the judge's metric in column 5, his suggested factor of 2 is not generally the case at all. Look, for instance, at Huawei at the top, Ericsson in position 3, Interdigital in position 7, Nokia position 10, Qualcomm just below halfway down. Now, my lords, this is a hangover from one of the major errors the judge made in his draft judgment that had to be corrected, and we'll come back to that. But it's just not the case that it's roughly half the rate. Now, my lords, the next step the judge takes, para 466, is heading creating a degree of equivalence. Now, one might have thought if the ultimate aim was to assess the overall price of the whole stack, one would just add them up as the total ad valorem price and add the stack shares, giving you an overall ad valorem rate or the percentage fraction of the stack covered, which you could then, of course, scale up to 100. But inexplicably, we say, the judge considered that each individual ad valorem rate had to be comparable with each other. And you can see what he means by this. He says in paragraph 466 that he has two choices: scale them all to 100% or turn each into an ad valorem rate for 1%. And my lords, you'll see the same quirk when the judge addresses his lump sum rate exercise. And can I just pause to tell you what the effect of this step is? It's to give a rate that one might assume would be payable for 1% as regards each licence in isolation. So the licences which are in fact for less than 1% of the stack have their importance inflated, and those that are for much more than 1%, so Qualcomm or Nokia or Ericsson or Huawei, have their importance diminished. The judge doesn't seem to realise this, but that is what he's doing, and is done in table 10. And the end of the table, at the foot of page 473 of the bundle, is a series of rows which aim to draw out the difference between the total and average rates that the judge gets from the licences when split into Apple and Optis licences. And the point of this is to identify the difference that the judge discusses in para 467 to 469. Importantly, the judge recognises, this is para 468 and 469, that these differences might be due to error because of small size of the Optis stack share. Can I just draw attention?
You're going too quickly for me. Can I just understand, just give me one example of what was done to the figures in table 9 to produce the figure in table 10. I understand what the judge said in 466, but I haven't in my head worked out what that means.
If you've got one that represents a stack share which is, say, 0.5%, you double it up. So you're saying, what would this be if they were all representing 1%?
I see. So if you take a stack share of 0.5, in order to produce the figures in column 4 of table 10, you've taken the percentage figures in column 4 of table 9 and doubled them.
Only for those where the stack share was 0.5.
Yes.
What you're doing is scaling.
So for each row, you scale the, I'm going to call them the blue numbers.
Yeah. The blue numbers have been divided by actually the stack share.
But I don't understand this, because the premise of the exercise is that we should be reflecting the percentage of the stack that each set owner has. So why is one doing this in the first place? Because it's contrary to the starting premise. Does the judge explain that?
No, he doesn't. And I absolutely agree with what my lord has said. And when we get to the grounds, where this is subject to one of our grounds, I'm going to illustrate with a really simple example how you get the most absurd results by doing this. You get the most absurd results. But that's what he's doing. He's basically saying, I've got all these prices for the stack shares that I know what they are, and I want to scale them all as if it was just 1% for each. And that's why I say to my lords that what he's doing is diminishing those that actually are the really important ones. So the ones that are 8% or whatever, he's dividing by 8. And he's boosting the ones that are tiny.
In a rational world, you should disregard the minnows,
Well, you might
not
disregard them.
whales.
You might do that, my lord, but an alternative, at least, is if you're paying whatever it is you're paying across 5 licenses for an overall share of the stack of whatever it is, you just add them up and work out what the stack is, and then you scale from that.
Yes.
And the point about the 1% is that what you're actually doing is you're not, in a simple way, just dividing by one of those digits. I don't know if these numbers are confidential or not. The number for...
The stack share is not confidential,
Okay,
but I think the individual...
Taking at random a number, 4.15, what you're doing is you're not just dividing by 4.15, what you're actually doing is multiplying by 1 over 4.15, which I know mathematically is the same thing, but that's what you're doing, and that's why the 1% is referred to in the tag.
Yeah, you're trying to...
Because you're doing your units of percents, so that's why it's 1 divided by 4.
Yeah, my lord's right. But what you're doing is normalising everything as if it had been for 1%, even though you know some of them aren't.
Yes, thank you. At least I've got that.
But so that's what he's doing in the detail, and I agree with my Lord Justice Arnold that it's just contrary to the underlying premise of what you're trying to do. Now, I think I was on the point explaining that the judge actually understood that there might be problems due to the particular small size of the stack, and this is para 46. I think I'd moved to 467 to 469 and was particularly drawing attention to 468 and 469 within that, that there might be error due to the small size of the Optis stack. And I just draw attention to that now because it's a point I'm going to be returning to because it's very important. We'll see that initially the judge actually sought to address this by an exercise to take account of the possibility the stack might be somewhere up in the region of 1 or even 2%. But he got his calculations, well, catastrophically wrong. And when corrected, it proved that the opposite of what he was putting it forward for was the case, i.e. that the rates that you get are realistic from Optis comparables. So he simply deleted it, and we'll come to that in due course. But the point I'm drawing attention to at this stage is that he recognised the sensitivity as to the measure of Optis stack share where it's small, because you're then scaling up so much. And so it's a really highly sensitive thing.
Why is it any more sensitive scaling up from a small number by, say, double to scaling down from a bigger number?
No, because it's not the scaling up to 1%, it's when you then scale it to the total size of the share of the stack.
Okay.
So the point that my Lord put to me just then, you're right.
Okay.
So it's what you do when you've standardised the figures,
Yeah,
rather than the exercise in itself.
Yeah, exactly. And the problem is, if you're dealing with a tiny size portfolio, and then you say, well, what does that mean for 100%? If you were dealing with a number which is very small, and you've got so much more that you're extrapolating. Anyway, we'll come to that. And I'm just drawing attention to it at this stage because he recognises that problem. Para 470, subpara 1 and 2 on page 475, the judge concludes the Optis comparables other than Google don't give useful information. Let me be absolutely clear, it's not part of my appeal to seek to revive those agreements. The judge deals with Google separately at subparagraph 3 on page 476 of the bundle. And here he makes and rejects the suggestion that Apple had advanced that he should dismiss this license because Google would not have paid proper attention to it. The consideration of the license was significant, even to Google, and the judge notes in this paragraph that Google was able to look after itself in negotiation. Please note this passage, my lord. It's an important passage. The findings the judge makes here are to the effect that the Google license is a good comparable.
Sorry, I wasn't keeping up properly, but you're in 473.
470 sub 3 on page 476. my submission is the effect of those findings is in substance that it is a good comparable. It's one that would have been properly considered by Google in negotiating what to pay and agreed absent any pressure from Optis that Google would not have been able to resist. We see the criticisms the judge goes on to make are as to the accuracy of the ad valorem unpacking of it, but as I emphasised at the beginning, that's a different matter. In terms of it being a good comparable, that's the substance of the findings that he's made. And at subparagraph A in the middle of 476, that makes a point about how free release and simple ad valorem rates compare to the other Optis ad valorem rates and the Apple average rates. The last sentence is important. The Google license is the one Optis comparable that suggests the Apple rates are too low. An important finding as to the effect of that license, and a significant point when the Apple licenses are addressed with a proper understanding of holdout. The judge then turns in subpara B to express a view that the fact that these, that's the Google license and the Apple licenses, are lump sum licenses, Google could be said to be the poster child for why unpacking is a dangerous course to take. I have to say I don't understand why that's so, but that's, the judges obviously didn't like unpacking. Also in subpara B, the judge notes the overall consideration is of course high, but not commercially unworkable. But he goes on to say the implied ad valorem rate is indefensibly high. We will see this part of the judgment is the subject of the major reworking that I referred to when his errors were pointed out, and I'll deal with them in due course. Here, he doesn't include any allowance for what the rate might look like if one took account of the possible inaccuracy of the measure of the portfolio size. Say that it was in the range of 1 to 2%, which he contemplated when he did his cross-check before. And the number to which he refers, which is highlighted in blue, you can see what that number is, and you can see the extent to which that may or may not be indefensibly high, and you'll see just how different that number is to the thing that he thought he was dealing with when we get to it. The sums that he did before were catastrophically wrong.
I understand why you're not reading out the numbers, Mr. Speck, and I'm not going to do that. But just to make sure I follow what you've just said, the last sentence, which there says, indeed paying something for the license to 100%,
yeah,
is indefensibly high.
Yeah.
That something is a way of valuing the stack.
Yes.
And his point is that number is indefensibly high.
Yeah.
And are you here telling us that number isn't indefensibly high?
No, I'm not. I'm saying the number he had when he drafted this originally was nowhere near that, much higher. But what I am saying is the exercise he did. Let me cut to the chase. The exercise he did of saying, well, the Optis portfolio could be, say, 1% or even 2%, where he did some different sums. Let's take the midpoint of that. Let's take the midpoint of that, 1.5%. You know the number he's using now? It's about a factor of 3.
Okay.
So if you divide that, what I am saying is that a third of that is certainly not indefensibly high. So when you take into account this uncertainty in stack share, and I'm going to explain to my lords that when you do that exercise, you're actually checking the measure of stack share and the number for the royalty. I'm really jumping ahead, but
Okay.
but what I want my lords to understand is that doing the exercise the judge did to take account of where it could in fact be, it isn't indefensibly high. And it's certainly nowhere near what he thought it was when he did this originally. Now in subparagraph C, the judge turns to the issue of how it had been unpacked, in particular as to the information as to expected sales figures, and this was information from Mr. Blasius as to the forecast Optis prepared based upon information provided from Google. You can see that elaborated in footnote 488. I'm not going to read that out. And just as an aside, my lords should know that there's an issue as to those projected sales, and Apple has suggested that they're too low, obviously resulting in a unit price that's too high. And we'll come on to it, we'll see it in their recent correspondence that they've suggested an alternative source of sales data which increases the units by just over a factor of 2. Obviously meaning the unit price reduces by the same factor. I think it's a factor of something like 0.49. So there's that to take into account as well. And I'll come on and explain that in some detail when we get to it. But my lord, see over the page, so this is the top of 477, that the judge does his own version of the unpacking, and it's all highlighted in blue, so I'm not going to read it out, but it's pretty crude. He doesn't pay any regard to discounts one assumes would have been made for future sales units.
Can you just help me on this? You made the point that when you're unpacking historic licenses, it's useless to show what the sales were after the event, because of course nobody knew at that time what the sales were after the event.
Yes.
So what you need to have is the best evidence you can as to what people thought at the time the sales were likely to be.
Yeah.
Now that being so, what's meant by forecasts here? I mean, is when there's reference to Mr. Blasius's own forecasts? Does that mean forecasts he made at the time?
Yeah. Just going back to that point is that there was specific fact evidence from Mr. Blasius as to the forecasts that were created at the time of the negotiation.
Right.
And that is what Mr. Bizant used.
And as I understand it, that wasn't Mr. Blasius inventing numbers out of thin air. It was based on some information from Google, albeit not necessarily.
That was the evidence. That was the evidence. But my friends challenged that and criticised it because it's Mr. Blasius saying what he said that the forecasts were that Optis prepared.
Right.
And so there was a fight about whether that was a fair or proper way to unpack the Google license. And obviously, if the numbers are particularly low, that gives you a correspondingly high price. And the point that I was drawing attention to just then about the recent correspondence is that they have identified the source that Miss Guttridge generally used for sales, so it's still projections, and they've identified that the number could be, on that view, double the number of units.
What's that going to do with the price of fish?
Well, because I think they're basically suggesting that perhaps Google thought something different, even though Mr. Blasius gave evidence about...
But you need fact evidence as to what the parties thought at the time.
If there is fact evidence, that might be thought that that's the best way to look. But in some cases, you don't have that at all. So you look at the analyst's evidence and you take projections from that. So it's not...
I see.
And all they're saying is, look, this is what Miss Guttridge was doing generally, and if you did that, you get a different number. Right. It's not a point that is an unfair point for them to raise. We could have a fight about it, but both of them were attempts to say this is the best way of looking at the sales projections at the time.
Thank you.
Now the judge does his own unpacking, which is pretty crude. He doesn't pay any regard to things like discounts that you think is going to be done. And then this gives the judge an ad valorem rate that you can see in the blue at the top of page 477. And he suggests that Mr. Bizant has unpacked more aggressively, enabling a lower ad valorem rate to be obtained. I'm afraid it's another place where we have to pause because it's another indication the judge is getting in another muddle. What the judge has just done in this paragraph is a pretty crude unpacking, but it's obviously one that takes account of future-only units. It allocates all of the license consideration to the income from the future sales referred to here. So it's a free release approach, and it doesn't seek to normalise to 1% of the stack. So of the 4 Google ad valorem numbers in tables 9 and 10, that's free release, not scaled to 1% of the stack. It's table 9 on page 471, which is the equivalent to look at. And you can see about 2/3 of the way down 471, right hand of the 2 highlighted figures. Hold that in mind and go back to see what the judge says his unpacking was, saying Mr. Besant had then aggressively unpacked to enable a lower rate. It was just wrong.
So what I'm looking at the 2 numbers, the 2 blue numbers for Google in table 9.
Yeah.
Yeah. And I'm looking at the less one, a simple one, and a free release one.
Yeah. You want
Since it's a free release, you want free release.
Yeah.
And I'm comparing that number to the number at the end of the blue.
Yeah.
I see.
Yeah. And he's suggesting Mr. Besant's got a lower price by aggressively unpacking.
Which seems to be an ad hominem attack on the expert.
Well, certainly the word aggressively, perhaps. The point I was more focusing on here is that he's just in a complete muddle. I mean, it's not obvious what he's comparing with, but if he had understood what he was doing, what the right number in Mr. Besant's numbers were that he'd put there, he would be comparing it with a number where he'd never be able to say that it was lower. He's just got it wrong, and it's just a further indication, my lords, that he just hasn't understood what's going on, and it's perhaps a problem because he's started engaging in this method of his own. Either way, the judge concludes in subpara D that unpacking is a dangerous exercise, not by the experts in my submission, but certainly the judge embarking on his own attempt, perhaps.
So I'm still very confused. I'm sorry, Mr. Speck. So the
Sure,
judge
it's my
says
fault.
Mr. Besant clearly unpacked more aggressively than I have done, so enabling a lower ad valorem rate to be derived, which sounds like a criticism of, well, I think aggressively, to be fair, isn't meant to be that Mr. Besant was being aggressive in the sense of being aggressive. It means that the approach was one which worked in a, what you might call, aggressive way. But why is it a criticism of the expert on the side of this case that's on Optis' side to produce a lower ad valorem rate? Wouldn't you criticise him for producing a higher ad valorem?
Well, if the argument is that it's unfeasibly high, that would be a criticism because you're making it look smaller.
Oh, I see. Because I see. The point
Yeah.
is that ultimately Google, the point the judge ultimately makes is Google is too high,
Yeah.
and so this is being very aggressive to make it look more like real life.
Yeah. I think that's the thrust. I mean, he's definitely saying that Mr. Besant's done something which gives him a lower number when he hasn't.
Yes. And the point is the relevant number in the blue is not lower than the other relevant number.
Exactly. Leaving aside that muddle, with respect to the judge, what he's in substance doing here is simply pointing out that the results of an unpacking will depend on the assumptions you make as to the way negotiators were thinking. And so unpacking is not a dangerous exercise, and in fact, as I've already said, there wasn't in fact that much between the experts on most of this. Anyway, the judge is going to use this point as a reason to decide not to take account of these matters at all, i.e. to take the numbers of units to be covered, the precise figure that one takes for Google, whatever it was, whether it's the anticipated sales of Mr. Blasius or the slightly higher ones using the analysts. But we say that is not a reason not to decide to take account of sales figures at all, because the effect of that is to treat all agreements in the case as if they're the same in this regard. And that is what the judge does. 471 gives his conclusion. He rejects the attempt to derive an ad valorem price for the stack, the summary of his reasons that he's gone through is that the Optis comparables are useless, and the process of unpacking the lump sum licenses that might be reliable is rendered unreliable by the unpacking. So my lords, having looked at ad valorem, he's completely forgotten about DPU, although that obviously requires unpacking, so one might think that perhaps he thinks that unpacking the licenses for a DPU would be useless as well. The next section is G, is headed a preference for lump sum rates. And we see the judge refers to his preliminary view that it's better to price the stack in monetary rather than ad valorem terms. It obviously means total amounts of money. Like I say, he's forgotten DPU. You might think that could be a way of doing it in monetary terms, but he clearly doesn't mean that. We're back to him referring to a lump sum rate.
He says it's a conclusion driven by economic theory. What's the economic theory he's referring to?
I can't help my lord. I do not know.
What economic theory says that it's better to price something in lump sum rather than ad valorem terms?
I don't know, my lord. We can pick it up at 475, where the judge says, this is just after 474, he rejects the use of Apple comparables unpacked as not truly reliable, that he was driven to the alternative approach of assessing price stack on a lump sum basis. And he foreshadows what it's going to involve, using Apple comparables plus the Optis Google license, which was paid as a lump sum. And he says there are two further reasons to do this. The first, this is 4761. In substance, he says using the Optis license would be extrapolating 9 times from the same data point. What he seems to have in mind is that they all represent the same tranche of the stack, i.e. the Optis share. Conversely, the Apple comparables concern different parts of the stack, so in substance this is the opposite of the conventional thinking, that data concerning the same portfolio is the best place to start. He seems to be saying it's better to do the opposite and take data points from all different parts of the stack. It's probably part and parcel of his view that what really matters is who the implementer is. And the second reason, this is subparagraph 2 at the top of 478, addresses the issue of whether the price of the stack should be tailored to the implementer purchasing it. So it's exactly the point I've just foreshadowed. The judge is recognising that we made a submission that this was wrong and discriminatory, and our submission at trial was made in the context of the Apple approach and evidence, which was a long way from what the judge did, albeit it was said to be tailored to be specific to Apple. But the judge rejects our point, and the substance of the reasoning is that whilst it's possible to defend a one-size-fits-all in the case of an ad valorem rate, having the same lump sum rate payable by each different implementer, is self-evidently discriminatory. We're getting into a complete muddle now, my lord, where it's actually quite difficult for me to explain what the underlying rationale is. What he goes on to refer to is a bit similar to the point that we saw earlier about smaller implementers, because he goes on to refer to implementer A selling low volumes and low ASP compared to implementer B saying high volumes and high ASPs. And he makes the point that they shouldn't pay the same. And rather tellingly, in my submission, he makes my point for me 5 lines from the end of this subparagraph. He says, consider just the per unit rate that such lump sum price would have shows a discriminatory effect. It's extraordinary. He's actually looking at the unit price in order to assess discrimination, but he won't work in the unit price for valuation. He's concluding that it would be discriminatory if there was a different unit price. Quite so, my lords, and that's why all approaches in the cases involve valuation at a per unit basis. Whether it's ad valorem or DPU, that's why every approach in previous cases do that, and every approach in any case I'm aware of does that. The end of the subparagraph draws a conclusion that a lump sum price of the stack needs to be appropriate for the business of the implementer. And then he goes on to say that if the stack price is prorated amongst all involved SEP owners according to their stack share, it will be non-discriminatory. I think what the judge is really identifying here is that the reason working in lump sum pricing is wholly inappropriate in my submission, particularly where the calculations that are being done use lump sums taken from agreements with varying sales volumes, differing with cross-licensing with different volumes in as well, and not having any regard to them. It really is a complete muddle in my submission. And it continues, the next two paragraphs, 477, include the long quote from the cross-examination of Mr. Blasius. And 478, making the point that the bottom line is money.
I'm not clear what that means or what it adds.
Well,
I mean, obviously it's about money.
yeah. Well, I do the best to help, my lords, but what this is pointing out, I think, is that a price in ad valorem terms doesn't of itself tell you how much the implementer will pay, because you need to know the price of the unit and how many units. But of course, you might think that knowing the price of units enough when what you're trying to do is come up with a frand price. But anyway, I think that's what he's talking about, that without knowing the units as well, you don't actually know what the check in the post will be for. And the judge says in para 478 it's a trite point, but he also says it's important because it's the monetary amount that needs to be frand. And he says how that should be calculated depends on the circumstances. And it's again clear in this paragraph that he only has in mind ad valorem or lump sum as the alternatives. He's completely overlooking what actually the fight was. And the same mindset is apparent in the introductory sentence of the next section in para 480, where he says he proposes to value the stack on what he calls a lump sum approach. 481 makes the point he can only do this if he's of the view the comparables are sufficiently reliable. And then he sets out why he does that. He does think that in 4 subparagraphs. There are actually only 2 points in these subparagraphs. Paras 1 to 3 are directed to holdout and the judge's view that there's a distinction between legitimate and illegitimate holdout. And that's actually building on an earlier section of the judgment that is at paragraph 369 on 431. Just so your lordships have a note to where that goes, just to open that up in 431. It's the section of the judgment under the somewhat startling heading, hold up and hold out are prima facie legitimate, on page 431, and I'm going to be coming on to that as a topic. That's really what is being referred to. That his view on that is really the core of those subparagraphs in 481, little 1, 2 and 3. And there's another aspect of his view on this, is that perhaps timing matters. That really is the nub of what he's talking about in 481 little 3. And he seems to be thinking that perhaps what you could do now might be different, but what Apple were doing at the time, it was all right because the Supreme Court hadn't told everyone you shouldn't do it. I'm going to come on to that, but that's basically what 481 little 1, 2 and 3 are dealing with. And little 4 is dealing with market power. So the conclusion is that in fact these are reliable, and so that's 481, so he can rely upon them. And 482, back on page 481, the judge sets out what he calls his first cut. And this is introducing table 11, which is on pages 482 to 487 of the bundle. And in paragraph 482, he says the table sets out comparables he's using and then explains what the table shows, stating the last column, what he calls the metrics, is the crucial one. And he says here there are 8 metrics, A to H. There are in fact only A to G when you look at the table. And he sets out each agreement. And he says the first metric is the lump sum payment, identified in the agreement. And he's not adjusting for past or future payments. And at this point, he says he's applying a wholly forward-looking approach, which he likens to Mr. Bazant's free release. Subparagraph 3 on page 481, he explains metric B is the forward-looking term. Metric C is simply A divided by B, so the annual payment. He's assuming no discount for advance payment. It's that basic, it's just the total amount divided by the number of years. The fourth metric, D, is the stack share of the SEP owner providing the licence. He obviously means Optis where it's an Optis licence, and where there's a cross licence, he obviously means not Apple, he means the other one. And the fifth measure, as explained in subparagraph 6, is the Apple stack share, which he says is constant at 1.07%. And he explains that this matters because in some licences Apple provides a cross licence. And he says an important question is how that cross licence affected the lump sum described in measure A. So just pausing there, it's an important question that he said having to deal with it in the expert's approach, it's one of his subjectivities as to why he didn't like it, because they had to deal with it. But now he's saying it is an important question, and it is. The judge mentions that Apple was a net licensee and didn't make very much of the value of the cross license it provided. And just pausing there, that's no doubt because however large the stack share Apple enjoys compared to the counterparty, the number of sales Apple makes is vast in comparison. And that is the factor that the judge is actually going to ignore. And for metric F, he calculates what he calls the net stack share. So that's D minus E. The judge is ignoring that massive imbalance in the number of sales that are going either way in this cross-licensing, and he's just netting it off as a stack share. So if they had, just to illustrate the point, if they had about the same stack share, he'd basically say it was 0 or very small. Now finally, we're now at the top of 482. Metric G is the scaled up price of 100% of the stack. And the judge does this as a gross and net calculation. Basically, he's using either the percentage stack of the counterparty without netting off Apple's share, or he's using that netted off share. And the actual calculation he does is to divide the annualised royalty payment by the percentage stack share, either net or gross respectively. And he sets it out for over the next 5 and a bit pages, covering 20 licenses. And at para 483 on page 487, he considers the output of his exercise. And he begins by noting that there's no convergence to a single price, which he says undermines confidence in the figures. Indeed it does, my lords. What we do not see here, though, is any consideration as to whether this wide range of numbers he's obtained is better or worse to what he referred to as the subjectivities in the expert's unpackings. The points the judge makes here are first, this is para 483 1A, to exclude Grand Messer. So one of the four that its common ground should comes out, but not the other three. The next, subpara B, that the introduction of a cross-license stack raises the price, and his inclination is to use that value. But he notes that sometimes the netting off reduces the size of the stack so much that the net stack is reduced such that you get an artificially high value for the stack. And he gives an example of it, which I won't read out. Subparagraph C, the judge addresses the issue of small stack sizes generally, which he says are problematic. So again, he's recognising that. And he says that they're distortive because he suspects the pricing is not linear with stack share. Now, what that point actually means, if right, is that the fundamental premise the judge actually has built into this, that one can scale up to 100% by linear scaling, is just wrong. Anyway, what he says he's going to do to reflect what he says he suggests is a fact, that there would be a minimum price below which no bargain would be reached. He says he's going to adopt a stack share of 1% in all cases, or in all cases where the stack share is less than this. So that involves reworking the licenses he sets out in the following table. So what happens in table 12 is a recalculation of the price of 100% of the stack for 9 of the agreements. He's knocked it down from 20 to 19 by excluding Grand Messer. So it's about half of the agreements. And they're the small ones. I'm just pausing here to consider the substance of what he's purporting to do. He's saying, I'm assuming the price reflects 1% of the stack, regardless of whether the stack is in fact smaller. As we understand this, the idea is the small counterparty to Apple is in fact able to negotiate with Apple so they pay as if the stack share was 1%. And of course, this would be to reduce the number one gets when you scale to 100%. So if, for example, the share was in fact 0.5%, the effect is a factor of 2. You conclude 100% of the stack is 100 times the payment, not 200 times the payment. But that's what he's doing. And my lords will be aware that he's not interested in doing that when it comes to setting a price for Optis. We get a fraction that's below 1%. But anyway, there's an inconsistency there. But that's the exercise he's embarking on here. However, it's not as simple as I've indicated, because as we shall see, the judge actually picks and chooses whether to take this recalculated number into his assessment or not. And in fact, for most, but not all, he goes back to the number he derived without this process of reworking. So he's done this exercise for 9, saying he thinks that nobody will pay for less than 1%, but then actually rejects it, as we'll see.
And these 9 are the 9, are they, that were less than 1%?
Yes. Yeah. Well, Grand Messer was as well, but he'd thrown that out.
Yes, sorry.
Yeah. At the foot of page 488, we get to the issue of Qualcomm. And as the judge said, this is controversial. And this is actually where I need to show my lords what the judge had done in the draft judgment too. So you need that out as well, if you can. And that's in core 2. Tab 2. Just to put you into the right time frame.
Well, just before you go any further, can I be clear? Because you've already referred to calculations that were either excluded or reworked.
Yeah.
So I take it you're going to be taking to those later. But does it make sense to deal with this one in isolation?
I think it does.
All right.
The The reason being is I have to show you how we got to this part of the judgment. The other one, because it was deleted, I can deal with later.
Okay.
That's why I've chosen to do it slightly differently.
All
Um,
right.
so this was a judgment that we got in draft in March 2023, so about 9 months after the trial finished. And what my lords need first is page 327 of Core 2. And this is the place where we see the table we've just been looking at the top of the page. So the one is the equivalent of what we've been looking at 488 in Core 1. The table numbers are off by 1 because of what came out, but what you see here is the peculiar passage I just drew attention to under the table. Actually, I leave that point. What you see here is that if you look in subpara, what was subpara D concerning the Google license under the table on page 327 has gone. And what you do find at the foot of 488 is that Qualcomm, the inclusion of Qualcomm, has been shuffled up to D. And what happened, my lords, is that the calculations that he did in respect of Google were seriously wrong. And if you look, for instance,
Several orders of magnitude.
yes, yeah, he calculated, I'm not going to read it out, but if you look at table 11 of the main judgment, so before treating the agreement as covering 1%, so this is page 486 of the core 1, top of the page, you see the gross and net figures in box G and compare that to what he thought when he initially wrote the judgment on page 325, core bundle 2. He's actually out by a factor of somewhere between 150 and 200, my lord. It's that wrong.
And without chasing it through, can you identify the reason? Well, what error did he make?
It's more than one, I think.
It's more than one, isn't it?
Yeah, if I remember correctly, one is getting the stack share expressed as a percentage wrong by the 2 decimal points for the percent. So 1% is 0.01. So I think he made that error. He certainly made that error at some point, but it's more than one error, if
Yes,
I recall. And I mean, he's out by a factor of between 150 and 200. It's that bad. And the numbers that he obtained when we corrected it and he reworked Google to treat it as having covered 1% of the stack were also wide of the mark. For that, you need to compare the Google entry in table 12 on page 488 in the judgment in core 1 with the numbers in table 11 on the draft in page 327 of core 2. That was an order of magnitude out.
Sorry, which numbers are you talking about now?
Yeah, I'm looking at Google in table 12 on 488 in the judgment. So this is where.
Oh, sorry, yes, I see what you mean. You mean the numbers in table what is 13 in the draft compared with the numbers in table 12 of the handed down version. are also very different as in the numbers in table 12 of the handed down version. And
Exactly.
I see. So
And that no doubt.
those numbers relate to each other. I mean, that's not that simple.
Well, that's your point, isn't it? Yes.
Yeah, so it's one order of magnitude, not several others wrong.
Here it's 1.
Earlier
It's more than 2. It's between 150 and 200.
Yeah.
So I thought perhaps my lord was referring to that, so you were right about that one.
So this might be the decimal point.
Perhaps, I don't know.
Yes.
But this no doubt explains why he deleted what was para D in the draft at 327, addressing the level of the stack price he derived from Google. But we've seen, even with those catastrophically wrong calculations, he actually was of the view that he expressed there about Google and the extent to which it would have been negotiated properly. Now, the reason I'm showing you this as the intro to Qualcomm is because it has an effect on Qualcomm's position in the tables. As for Qualcomm, the judge also got in a complete muddle. At this point, I can just point out the discrepancy in the main judgment, table 11. So for that, we need core 1, page 485. The numbers for Qualcomm are towards the middle of the page. You see the number in box G. And you can see the total consideration in box A is made up of the components identified there. I'm not going to say anything about it other than just draw your attention to it. In the draft judgment, my lords see at 324 of core 2, the judge has done his calculation using the numbers for consideration that he identified at A there.
Right, I'm not with you. So I'm on the table in the draft judgment.
Yeah.
Right.
Qualcomm. 324, the judgment. Yeah, draft judgment in core 2. Look at the royalty payment that he has there.
Okay, so it's a different number from the royalty payment in the final
Yeah.
judgment.
And so this is the error. What he's put in as the consideration differs.
So at that stage, he'd missed an element.
And so that meant his box G numbers are wrong as well. And of course, there's no reworked version deeming the stack shares to be 1% because of the size of Qualcomm's stack. So you just have this table to look at for that. So, I mean, not that it's much comfort, but not so way off as the Google numbers, but still a very significant discrepancy. And we will see what the judge decided to do with Qualcomm as a result of this being pointed out. But he got in a complete muddle on both of them. Before I leave that, I'm not going to go through where they all are, but he got his numbers for Ericsson wrong, Huawei and CCE, I think in the latter case by a factor of more than 50%. It was...
And when you say wrong, what you're talking about wrong is the judge's calculations don't do what the judge said he was going to do. You see what I mean?
Well, I think he...
It's not just that, because the example of Qualcomm, his starting figure is wrong.
Yeah, that's why I hesitated.
Before he goes any further.
That's why I hesitated with saying,
Yes.
definitely,
So
he's got the numbers wrong, and I'm afraid I can't remember the detail of each of them.
Right.
But my Lord Justice Arnold has expressed the point that was causing me to hesitate.
Yeah.
However he did it, he got it wrong. So they're all over the place in my submission.
So if one compared the draft table and the final table, one would see these discrepancies.
Sure. And some of the numbers are, as I keep saying, catastrophically wrong. And one of the issues is that he clearly formed his view as to my client's case on the basis of a view that was just catastrophically wide of the mark as to what we were advancing. and that is a real problem in my submission. I need to deal with the text relating to Qualcomm at the foot of 488 of Core 1 next. So the bottom of 488 over to the top of 489 in the main judgment. And the exercise the judge does in his table 13. The text, which is subparagraph D now, which is the same as the reasoning in the draft where it's in fact subparagraph E on page 328, relates that Apple contended that Qualcomm should be excluded as it gave a high number, but Optis contended that it was important for precisely the same reason. Now in the main judgment, we then get to the introduction of the judge's table 13, and we can concentrate on the judgment itself to understand the judge's explanation as to what that's doing, although I do want to draw attention to the differences in the draft judgment in these passages, so perhaps if my rules can keep both open. So we want pages 489 and in Core 1 and 328 in Core 2. And I'm going to stick mainly to the actual judgment in Core 1. So I'm on para 483 little 2 on page 489. And what the judge has done here is to take the licenses he's using and arrange them in descending order depending upon the table 11 net number, which, as the judge explains in subpara A, is his AV1 in the column. So they're ordered backward through to Pantech, as the judge mentions in subparagraph A. He's excluded Grand Mesa. But please note Google's position. It's at number 16 out of 19. But note what the judge wrongly thought about Google when he prepared his judgment and got his sums all wrong. Look at its position on page 328 of Core 2. It's actually table 14 there. But look at it. So that's the effect that it had as to its position. Turning back to Core 1, subpara B on page 489, explains what the judge's AV2 is. That is to reflect his adjustment to assume 1% of the stack share. So that's as regards those in table 12. So it only includes a different figure for those that are in table 12. The judge explains this in subpara B. He says that in some cases these adjustments make obvious sense in that they adjust for tiny portfolios that are clearly outliers. Strangely, the judge goes on and says, no doubt because these adjustments were already made in negotiations, he considered the adjusted rates to be inappropriate in most cases. My lords, this has caused me a considerable amount of head scratching. The sentence that refers to the adjustments already been made in negotiations seems to be suggesting that there are cases where the negotiations had made the adjustments this column is intended to make. And if we recall, this adjustment is supposed to be taking account of the idea that parties will not negotiate a price lower than for 1%. So it appears to be saying in negotiations there are cases where they will have made this adjustment, i.e. decided not to go below the price for 1%. In fact, he's saying in most cases, but that would mean he does need to adopt the table 12 figure. But he says the opposite. If you think it's happened, you need to put the price in on the basis of what you think's happened. But he says the opposite, which means he's going back to the numbers that assume the lower stack share. I mean, I might have misunderstood what he's saying. It is a complete muddle in my submission, but it looks like he's saying he thinks they did it, and if that's true, the logic of it is he should have adopted it, but he doesn't. And in fact, my lords can see that when he says in some cases it's good sense and he's going to do it, some cases plural, there's in fact only one agreement where the judge takes the figure from AV2, and that's the one shaded grey. in the judgment. So the upshot is he's really saying his idea that parties don't negotiate below 1% doesn't apply at all, save for one. In fact, there's no evidence to suggest that happened in that case. Just the judge didn't like the number, so he was going to take a different one. So when he says the AV2 number is inappropriate in most cases, he means all cases save for one. And it's worth looking at how we got into this particular muddle, because if we go to 328 of core 2, subparagraph B, at that stage the judge has intended to apply this point to just 2 licenses. And he said it made obvious sense in 2 cases. It's pretty inexplicable as to why he changed 2 to some when he was putting it down to 1, but that's how we got into this model. Now, returning to core 1, page 489, we see at subparagraph C, the judge explains that the column shaded grey in the figure is the one he prefers between AV1 and 2, and he says that that's what goes into AV3. So that's all that's happening between between AV2 and 3 is one of AV1 or 2 is being transposed over. And to complete the table, AV4 and AV5, as the judge explains, is excluding the top and bottom 5 or 3 respectively. And it looks as if it's the basis of the AV1 figure that decides whether they're in the top or bottom 3, because that's the number that's in the column and then crossed out. So that's what he's doing. And one thing to note about the significant change in position of Google in this list is that Ericsson moves up to position 3, so it gets excluded in the AV5 calculation. It wasn't so in the initial draft. Now, all this complication leads in the judge setting out the numbers in table 13. He explains this in subparagraph 3 on page 490, that they're 5 averages. So I'm now back in the main judgment, the foot of each column. He says he doesn't think AV1 is reliable.
Just before you do, looking at the columns,
Yeah.
in AV4, Google is crossed out but not in AV5. Is that a mistake?
Yeah, no, I don't think it is actually, because although AV5 isn't the bottom 5, it's the bottom 3.
Is it not in the bottom 3?
Yeah, he's right.
Oh no, maybe you are right, because it is still in the bottom 3. I was counting up and including a figure that's a total, sorry. I think your lordship might be right.
And if it's the bottom 3, I'm not sure why the figure above that is excluded. But
No, you're right, you are right. I mean, when we get to it, he doesn't use it.
No.
But, I mean, that's an error that I hadn't spotted, my lord.
Yeah.
You're right. Sorry, I'd forgotten that the 2 numbers at the bottom were not part of this. So I think you're right.
yeah.
I think I was at the stage where I was saying the judge says he doesn't think AV1 is reliable. He says it contains outliers that are obviously distortive and identifies one as in particular. In fact, there is only one, I think. Subpara little 4, I'm back in the judgment in core 1, 490, explains the judge prefers AV3 to AV2, perhaps not surprisingly given that AV3 is the column of his preferred averages, or preferred numbers. And he explains that AV4 and 5 eliminate what he calls outliers, the effect of which is to exclude what he calls the most valuable licenses, and by that he clearly means those that translate into the highest lump sum. Now, just following this through, subparagraph little 6 on page 490 is a subparagraph that focuses on Qualcomm and identifies Qualcomm as the reason that AV4 and 5 are lower than AV2 and 3. And this is what the judge refers to as the distortion, which he plainly means the feature identified at the end of the previous subparagraph. And this is new in the sense it was not part of the reasoning in the judge's draft. Perhaps not surprisingly, as there were 2 licenses above Qualcomm in the judge's table that's equivalent to table 13. At that point, this is subparagraph little 4 on 329 of Core 2, the judge expressed the view, the view that the better course was to include Qualcomm, as he wanted as many reliable outliers as possible, and Qualcomm would balance exertion of market pressure on smaller counterparties. Please note the inclusion of the word reliable. So there's a change there, and back in Core 1, page 490, the judgment at little 6, the judge points to the different result one gets with and without Qualcomm in. And he draws attention to the proportion of the total of sum paid. I won't read the numbers out, but I do draw attention to the fact that the number he gives is in fact the proportion of the AV3 column, so a notional total where each agreement has been scaled to 100%. And he's adopted that adoption for that adjustment for the one at the top. Now, my lords, the next subparagraph 7 including all the subparagraphs A to D on page 491 are all new, save for the introductory words stating that he thought long about it. And it's here we see the judge explaining what he's going to do with Qualcomm, which is a major change from what he did in the draft, which, as I've just shown you, was to include it for the reasons we saw him give. Subparagraph 7 on 491 of Core 1 is also new, which we will see when we get to it. The judge recognises what he's done would make a statistician blush.
Subparagraph 8.
Yes, 8. Did I say 7?
Yes.
I do apologise, you're quite right. And indeed it would, my lords. And in fact, it's rationally unsupportable and not contended for by either side. And in my submission, what he does, and I'm going to go through it slowly, is no better than generating a random number in about the ballpark under consideration, and then claiming it's information that can be representative of the Qualcomm agreement. So let's take it slowly. Before I do, can I just remind you of 2 points? First, the text in the judgment addressing Qualcomm earlier in the judgment, 263 to 265, recites the dispute over Qualcomm and concludes that the judge can't resolve them. That text remain unaltered for the draft. There's also paras 263 to 265. So none of that's changed. And the second point is that this reworking of his judgment arose because the judge had got his sum so wrong on Qualcomm. It was agreed that true consideration was higher, and as I pointed out, the correction that was necessary you saw in the table where you saw what the actual consideration should have been. And we say the judge just didn't like the change in the answer, and we'll see how he changed his approach and how the number he ended up with changed, or rather didn't change. In fact, it went down somewhat. Let's look at what he does on page 490 of Core 1. The judge now says there is a compelling case for exclusion of Qualcomm, but he's decided to make an adjustment rather than exclude it entirely. So one might think he's going to do something to the Qualcomm number, but no. If you read on, read on, Judge says at subpara A over the page that the number of comparables is limited, so he should beware of excluding evidence unless justification is clear. In sub B, he refers to including a licence as a helpful corrective for those cases where Apple may have exerted their own market pressure. So he goes on to say it would be an error to include Qualcomm in an unnuanced way. And he says he sees the argument for excluding it, but then the upward, i.e. the corrective effect, would be lost. So we see what he's going to do in subparagraph C. He's going to change the Qualcomm figure in his AV3 column, and he's replacing it with the AV1 average, which includes, among many of the numbers that are put into that average, the high Qualcomm rate, and in fact the higher rate of one others. But it has all the others in too, the low ones. So the exercise, that average in AV1 at the bottom, is a simple averaging of 19 items. And he's going to use that and put it in the AV3 column and average it all over again. My lords, the submission I make is the number that he uses has got nothing to do with Qualcomm at all, really. Qualcomm buried away in it with all the other tiny numbers too, part of the averaging. Its contribution is watered down to basically nothing. As I say, it's being averaged twice over in the whole process. The judge was absolutely right in subparagraph 8 about statisticians blushing. It's completely irrational in my submission to purport to be including Qualcomm in a nuanced way, but then simply to look around in the materials for any number lying around that's roughly of the right order of magnitude is no more than that. Having slashed the overall cost of the stack by this revision to his method, things get even worse in paragraphs 484 and 486. This is where we lose getting on for another factor of 2. These 2 pages of the judgment are particularly costly for my clients in terms of downward effect caused by the judge's errors. And this is another area where I need to show you what the draft judgment did. So we need core 2, page 330. We see the heading value on free release basis. Do my lords have that in core 2? And the judge explains at paragraph 484 in that, so in the draft, that the valuation he's come to is on a free release basis, an annual fee for a year's access for the entire stack. The judge says his calculation has ignored the fact that the price is based on a series of comparables, the vast majority of which involve past releases. So he says the price will be too high because he has disregarded the question of past release. Assuming that the release has no value and that the lump sum was all attributable to the forward-looking licence, is when you're having too high a number. So at paragraph 485, the judge says some form of adjustment is needed to reflect the backward element. He says it's not possible for reasons he's given to undertake any kind of reliable comparable by comparable unpacking of this issue. The comparables don't differentiate between past release and forward licensing. So the judge says he'll apply a broad brush. He says on the evidence in his table 10, it is clear sums payable in respect of the comparables needs to be split 50-50. He's referring to his table 10 on page 311 and 312 of core 2, showing ad valorem rates of Apple compared of Apple comparables on free release to a number highlighted in blue that he compares on the simple basis. So if we're looking at the bottom of 312, 2 up, do you see that? Total Apple comparables.
Sorry, I got lost. Where
Yeah,
are
it's
you?
me trying to take it too quickly. It's not exactly my fault. 312 in the core 2, so the draft judgment.
Yeah.
And not the bottom row, but the one above that where it says total Apple comparables. And the point is, one's about double the other. And as that comparison is his reason to decide to adopt a 50-50 split, which means he halves the annual price to be paid for the stack. If we go to the judgment in Core 1 at 473, page 473, the same numbers, when corrected, are now not 2 up from the bottom on this table, but if you're on 473, you go 4 up, you see total rate Apple comparables. You see that? It's the same table, the same entry is total Apple comparables row, now 4 from the foot of the page. The error the judge made in his assessment meant the numbers changed significantly, and the comparison he was seeking to make before simply doesn't support the reason expressed in the draft. The split is nowhere near 50-50. One might have thought this would lead him to adjusting the split to reflect the corrected numbers. But if we go forward to the equivalent paragraphs in the judgment, so 484 and 485, the judge makes exactly the same points in 484 as the draft, but the next paragraph has changed a lot. Now, after stating that the agreements do not differentiate between past release and forward licensing, the judge says this: as a matter of principle, and ignoring the time value of money, i.e. interest and discount for payments for the future sales, one would expect that a past release ought to be priced at the same rate as the future license, and that a 50-50 split would be appropriate. The language used as to the conclusion on the price of the future sales on the past sales is that they ought to be priced at the same rate. So he's not even considering the point that different sales may actually be covered in terms of numbers. He's simply saying the price should be the same. Of course, we know, indeed, they should be in terms of frand. But what the judge is doing, though, is losing sight of the fact that they ought to be of equal value as a matter of what they ought to be for what's frand. But what he's doing here is seeking to work out what in fact happened in the past in those agreements before him. And this is an error this court's seen before. And we see it very clearly if we read on. The judge refers to the split in his table 10 as being the split that the evidence suggests. And he says that's very far from 50-50. So he gives the number. It's highlighted, so I won't read it out. He says that's very far. So pausing here, he's recognising his corrected figures are very different, and he's coming up with a completely new reason to stick with the 50-50 split that he wants to use. And reading on even more, we see he says the split suggested by the evidence is unprincipled, and he says evidentially very dubious. His eye is on what it should have been if frand, rather than assessing what in fact it was. And we see it even more clearly in the penultimate sentence of the paragraph. The judge says the 50-50 split is called for, and as he will come to, will best disincentivise holdout. But of course, what is frand is not the same issue he's concerned with in para 485, which is how to assess the value by assessing what actually happened in agreements that have already been negotiated. They may, indeed often will, have non-frand features. And heavy discounting for the past is the paradigm feature of a real-life licence that's not frand. And my lords can perhaps see the point most clearly by just pausing to consider this question. How does treating these licences executed in the past as having treated the past and future of equal value, disincentivise holdout. How does it do that? These licenses are done in the past. In fact, what this is doing is rewarding it, because it's baking in the non-fran reduction into the price that you assess and take forward for the future. It can't have any effect on the licenses that have already been agreed and are in the past. Anyway, that's what the judge did. So he stuck with 50-50, even though the evidence was that it was a long way from that. And he reached the overall annual price to be paid by Apple for access to the whole stack, the entirety of all SEP holders. There's 1.35 billion. That's para 486. Which of course the judge prorated to the share of the stack to get his annual figure payable to Optis. And just to sense check that, the 1.35 billion, this is per year, for the whole stack, compare it, for example, to what Apple paid Ericsson with a 4.15% stack share. But if you go to the bottom of page 482, I'm not going to read the numbers out. The sum paid and the period shown is in boxes A and B respectively. It's pretty illuminating to just do that comparison. For a 4.15% stack share. My lords will be pleased to know I finally reached the end of going through the judgment to show you what the judge did. And I hope my lords will understand why on this side of the court there is a considerable amount of worry about not just the individual decisions that the judge made, but a real worry that the judge and everybody else in court, both sides, the experts, the barristers, were ships passing in the night. The judge just didn't understand some of the fundamental things that was going on. Can I now move on, having done most of the legwork, to pick up the individual errors of the judge's own method? As I said, I think it would be disruptive to move on to the overarching grounds of appeal, and I think the most convenient thing is to press on with the individual methods, the individual errors, sorry. So, picking up our skeleton, I'm dealing with what we called errors 1 to 6 in the judge's own methodology, which is our grounds 5 to 10. Apple have conceded 10, which relates to payments going back in the past. The judge has held that they should get it for free unless and until an implementer approached them, but Apple have conceded that that's wrong. So I need to cover grounds 5 to 9. And the first point that I've not dwelt upon yet is short and sweet. Ground 5 is para 108 of our skeleton. And the point is this: there were 4 Apple agreements that it was common ground didn't admit with meaningful information as to Fran. Those licenses were Grand Messer, KPN, Orange and Etri 2017. We give you the reference to Apple and Optis respective position statements in our footnote 105 on para 38 of our skeleton. Can I just show you our second one of those two, because we're agreeing with what they said, so I think I can pick it up there. It's core 3, tab 4, page 88. It's the first 2 sentences of para 17, just above the bottom hole, page 88 of core 3. And in fact, you see it in the judgment where the judgment itself reflects what Apple's position was. He correctly identified the 14 that they were relying upon at the top of page 364 in the judgment. So I'm looking at 364 and 365. This is the judge's own judgment, core 1, identifies what they did rely on, and then he identifies the 5 they didn't. Of course, we put Qualcomm back in, but it was common ground that the other 4 weren't useful.
So where was I looking on 364?
I was on 364 of the judgment, so I'm in core 1, page 364, not paragraph. Sorry.
Yeah, page 364.
Yeah, and you could see
Beginning at 363.
363 and 4. The ones relied upon on 363, the 5 that were not relied upon are at the top of 364. We put Qualcomm back in, but none of the others came back in.
Yeah. And the difference is the 14, as he says, at 239 were relied upon by Apple. 240 are the remaining 5, i.e. not relied on.
Exactly, yeah.
Yeah.
And the reason, like I keep saying, Qualcomm came back in because of our positive assertion, but nobody ever suggested those 4 came back in. And he goes through each of them in the judgment and explains what the position is on them. I'm not going to turn it all up, but you get it from page 365 onwards. Nothing is said there that would warrant putting them back in. And my lords, relying on something that it was common ground is not useful is a substantial error of principle. Our system operates such that the parties know the scope of what's agreed and what's in issue. Of course, they can cross-examine and make submissions accordingly. Obviously, it doesn't mean that the judge has to adopt the entirety of either side's case, but it's quite wrong in my submission for the judge to reject what's common ground, at least without warning. Now, what's Apple's answer to this? Well, it's equally short and sweet, but not at all persuasive in my submission. They deal with it at paragraph 12 of their skeleton. Sorry, 112 of their skeleton. They say the issue basically resolves into 2 questions. They say, first of all, did the judge explain why he decided to take account of KBN, Orange and Etri in his valuation exercise? And they suggest he did. That wouldn't be a good enough answer to my point even if he had, because he, apart from the common ground in the judgment after trial had been concluded, would still be quite wrong, as I've explained. However, my friends have another big problem with their submissions because they rely upon paras 290 and 291 of the judgment as support for the contention that he did explain why he decided to rely upon KPN, Orange and Etri. Now those paragraphs are just not addressed to these specific licenses. All those paragraphs do is address quite generally his desire to include more comparables rather than seek to focus on fewer, better comparables. He finishes 291 by stating his starting point is that it's better to include rather than exclude, and a reason for exclusion must be explained. But note what he says at footnote 421. He says he obviously can't include for reasons of basic fairness that which he's explained the comparables adduced by Optis which Optis do not rely upon, which Apple did not examine itself. Now of course he's not saying that about the ones that Apple didn't rely upon, but what's sauce for the goose is sauce for the gander, and it certainly means that what is being said here is not a suggestion that he is explaining why he's going beyond what was common ground and bringing in agreements which just weren't in play. So the passage my friends are seeking to rely upon just don't do the trick for what they suggest in my submission. What the judge is doing there is explaining why of those in play he prefers an inclusionary approach. Not that what he thinks he's going to do is disregard the common ground as regards the three specific ones that he then did include. Well, as I said, that's short and sweet. I don't propose to say anything more about that particular ground, which means I can turn next to ground 6, which is Qualcomm. We've seen some of that already. This is the judge's treatment of the Qualcomm licence, which we address at paragraphs 110 onwards in our skeleton. Qualcomm actually bleeds over into several points as we articulate in paragraphs 111 to 113. We explain it overlaps with the point on the judge's muddle over hold out and hold up, and the judge's reliance on other Apple comparables, and I'll be coming to that tomorrow. Related to it is the second point we make over the page at para 112. We draw attention to the fact that what the judge did was refer to the dispute over whether Qualcomm had exerted improper anti-competitive pressure to exert superfran payment, or whether in truth Qualcomm was simply the only company powerful enough to resist Apple's holdout. That's para 263 to 265 of the judgment that we looked at. The judge says that the issues are ancillary and he can't resolve them, although he would take them into account. And we saw when taking this into account, the judge had decided to include Qualcomm in his exercise. We saw that in the draft, Core 2, paragraph 329. And it came in because it was a reliable outlier, and his approach was to include as many as possible and acts as a balance in the cases where Apple exerted its own market pressure on smaller counterparties. So it came in at full value as to its consideration. It's just the judge made a mistake about that. So having decided the dispute over Qualcomm being inflated by improper conduct or simply illustrative that only Qualcomm was able to resist Apple's holdout, having decided not to decide that issue, he decided to include it at full value for the reasons we've seen. But the changes the judge made to his judgment are in substance to use a number that doesn't represent Qualcomm at all. We've just seen it. What he does is take an average from 19 agreements. It's no better in my submission than a random number generator. And one cannot say it's any attempt to represent anything from Qualcomm. So we have what we say is a logically indefensible position reached. The judge is purporting to include Qualcomm, albeit he says now in a nuanced or adjusted way, even though in the earlier narrative in the judgment hasn't changed from what it was in the draft where he was putting it in at full value. But the key thing is that he's using a number that just doesn't reflect anything from Qualcomm, and he doesn't seek to explain why it reflects anything from Qualcomm. It obviously doesn't. And I can pause and draw attention to the fact that the number that he uses is lower even than the number contributed by Ericsson. Qualcomm is the one that's supposed to be the reliable outlier, but he picks a number that isn't even as big as some of the numbers that are being put in from the other agreements where this is not suggested. So, my lord, the number's got nothing to do with Qualcomm. And my lords will hopefully understand why we say this is depriving Qualcomm of its corrective effect. My friends, I think, in answer to that particular point, say that it is doing something because including that number does raise the price above that which would be the average if you took it out. But that's not the point. The point is that it's arbitrary, and Qualcomm's corrective effect has got nothing to do with the effect of putting the number in. Now, my lords, what does my friend say in answer to this criticism about Qualcomm, the judge's treatment of Qualcomm? For that, you need paragraphs 114 to 120. And before we look at the detail of what is there, can I tell you what is not there? There is absolutely nothing here to justify using the AV1 average. They do not try to say it represents anything about the Qualcomm agreement, even as an estimate or an adjustment of it. What they do is firstly seek to persuade my lords to treat Qualcomm as being one where Qualcomm had in fact extracted an abusive price. Paragraph 114 to 115 addresses this issue and refers to the taken to the cleaners quote the judge referred to, together with referring to the evidence that the judge heard, although they don't mention the extensive cross-examination on that, or that the judge said he wasn't deciding the point. It's not entirely clear to me if they're seeking to argue that even though the judge said earlier in the passage he wasn't deciding the dispute, he in fact did when he reworked the judgment, or perhaps they're seeking to persuade my lords to come to that conclusion now. It's not clear, but they're certainly seeking to suggest somehow or another that the price was excessive. Either of those approaches would be quite wrong in my submission, and I will shortly show my lords how it would be quite untenable to conclude Qualcomm was a hold-up licence. But before I do that,
they make reference to a decision of the CAT and the Korean Supreme Court. Was there a debate for the judge about those? And if so, what was the answer to Hollington and Hewthorne?
I'm not sure it's Hollington and Hewthorne, because I think I'm about to show you there was a debate about some American proceedings as well, but not because of findings in the American proceedings.
Well, there seems to be a suggestion that they can somehow rely on findings of abuse of a dominant position by Qualcomm, made by other courts, and indeed in one case in another jurisdiction.
Yes.
And prima facie, that's contrary to Hollington and Hewthorne.
That is contrary to Hollington and Hewthorne. It's not the debate that we had about the American proceedings. That is just to do with the stance that was being taken. We did have a debate about whether or not that was a thing that would help the judge at all. I can't remember the precise. I definitely remember Hollington and Hewthorne was part of the debate.
At all events, whether it was debated for the judge, as I understand it, there is no finding by the judge that he's entitled to rely upon those findings and that it supports his conclusion.
No, absolutely right. They're trying to throw it in now. So, but I can't say to my.
And have they got a respondent's notice on that?
They've definitely got a respondent's notice that raises some points.
All right.
I'll look.
That may be a matter for them.
It may be a matter for them. Either way, my lords, either of those approaches would be quite wrong, and it would be untenable to conclude that Qualcomm was a hold-up licence, as I will show you shortly. But before I do that, can you look at the end of paragraph 115, because it's worth looking at that closely, they refer there to the consequentials judgment, so given on the 24th of February 2024, nearly a year after the draft judgment, 9 months after the judgment with the revisions. And they point to one sentence in his brief reasons for refusing permission. It's page 54 of Core 2, if you want to look at it. So it's tab 1, page 54. And it's the paragraph dealing with what were grounds 2 to 5 being advanced then. So about 2/3 of the way through that paragraph. And they refer to the judge saying all that time afterwards that the court's assessment of the Qualcomm licence was based upon the court's assessment of the extent to which Qualcomm used market power to extract a high and non-market price from Apple. I make 2 points about this. First, it's rather telling that Apple have to go here to try and support their argument rather than the judgment itself. That's not what the judge says anywhere in his judgment. And secondly, perhaps related, what is it that they're referring to in the judgment? Where is that assessment? Of course the price paid to Qualcomm is higher than the others, but as the judge correctly records, both sides were relying upon that fact, and he didn't do the assessment now claimed. And paragraph 116 of Apple's skeleton is perhaps where we see most clearly the absence of an explanation as to how this exercise is taking account of Qualcomm at all. This paragraph recites what the judge did using the AV1 average and asserts that this is taking Qualcomm into account and striking a balance between excluding evidence and including a comparable that distorts the figures. But they make no attempt to explain how this is logically supportable as something representing Qualcomm at all. Paragraph 117 of Apple's skeleton is the point that adding the number in compared to excluding Qualcomm has an upward effect. But again, that misses our point. It's nothing to do with Qualcomm at all. And as I've pointed out, it's actually plucking, in substance, a random number. That leaves paras 118 and 119, because para 120 doesn't contain a further point. 118 expressly mentions 2 points I've already touched on. First, the unfairness of apparently treating the licence as a hold-up superfran in the absence of a finding that it was a hold-up licence. And in paragraph 119, my friends characterise our complaint as based upon a proposition that the trial judge can't treat one comparable differently from another unless the comparable is found specifically to be the product of non-fran behaviour. As they say, there should be no such black and white approach. But of course that's not my proposition, my lords. My point is much more specific than that. To the first one, it's unfair and quite wrong to state that you're not going to decide the dispute as to whether the Qualcomm licence is hold-up or superfranned, but then appear to treat it as if it was so tainted. And it's even more unfair for that to come out in the way that it did, initially deciding to include it, but subsequently, while still declining to determine the dispute, not deal with it in the same way when the numbers are corrected. And as to the second point that they make in paragraphs 118 and 119, it's our contention that Qualcomm, what the judge did with Qualcomm does rob it of any corrective effect. Because you're putting in a number that's much lower and has got nothing to do with it. Can I finally, on Qualcomm, take a few moments to completely put to bed this idea that Qualcomm is a hold-up license? And if the judge had resolved this issue, there's only one rationally supportable conclusion. And we can see the answer to this very clearly set out. I can do it by reference to our closing, which is in Sup 1, tab 3. And my lords need pages 78 to 82. Of the bundle. Can I just take my lords through this so that you see what the debate was and why I say it's completely untenable for it to be held to be a hold-up license. The thrust of the argument as to Apple being over a barrel because of Qualcomm's no license, no chip policy as identified in paragraph 636 and 637, where we point out that Miss Muse, Apple's witness, did not mention anything about the litigation started by Apple. And we summarise in paragraph 638, the suggestion was of hold up because of being over the barrel because of that policy. Turning over the page, we make the point that there's a world of difference between market strength to enable a company such as Qualcomm to resist hold out by Apple, and that meaning there's a risk of hold up. And the reason the two are poles apart, as we identify in para 640, is that crucial difference is that hold up and hold out strategies both involve avoiding a court determination.
Hence all the recent cases about interim licenses. Yes.
Exactly. My lord has it exactly. Both of them involve avoiding a court determination of FRAND and putting pressure on the other party to accept a deal that deviates from FRAND. And the point we make is that if a court determines FRAND, that will be it. FRAND determined and no ability to get a better deal above or below, whichever you're going for. And we draw attention in para 641 that a party that holds out cannot go to court to get a determination of the rate that they would otherwise get by holding out, because all it's going to get is FRAND. And that is why, my lords will recall, Lord Kitchen was alive to implementers not submitting to an appropriate FRAND adjudication. We'll come to it, but it's all part of this. And so we also say an implementer always has this option open to it. That is going to court to get it determined. And we say in para 642, we agree Qualcomm was able to prevent Apple from holding out. But as we explain in 643, it's not the same as saying Qualcomm extracted supra-FRAND rates. And we really get to the nub of it in 644. An implementer can bring a FRAND determination before the court. And absolutely key, it's plain beyond peradventure in this case, it was Apple, not Qualcomm, seeking to keep the global portfolio FRAND determination out of court. It was Apple that did not want a true FRAND rate determination, even against Qualcomm. And please note what we point out in the sentence bridging the page. Qualcomm tried to have it determined in the US proceedings, but Apple objected and made it clear it wouldn't accept the licence determined by the court. And we shall see, my lords, this is not me attempting to characterise what happened. It's absolutely clear and was accepted by my learned friend for Apple before the judge. And it was said to be because, just like in trial F that my lord will have seen, a fear the court's going to get it wrong. It's exactly the same policy. They come to a rate that was not to Apple's liking. So if we read on, I'm now at 645, we say Apple knows full well that an implementer can seek specific performance in the US courts, and we've referred to a well-known case concerning Apple with Motorola from 2012. And then paragraph 646, we refer to the asymmetry between the position the implementer and the patent owner have, and that's due to only one of them being on the hook with the FRAND undertaking. And we go on and explain they relied upon it very heavily in litigation with Qualcomm, and you see a reference to footnote 5 in cross-examination bundle document. In fact, that's a reference to a judgment that we have in the authorities bundle 5, tab 2. Can we turn it up because it's illuminating? And this is not relied upon because of any kind of finding. This is not a Hollington and Hewthorne objectionable call. So I'm going to show you what the stances they were taking in the litigation.
I'm sorry, I didn't pay sufficient attention to where I should be going.
No, I'm taking it too much of a lick, I'm sorry. Authorities bundle 5,
Yeah.
tab 2. And this is Qualcomm seeking to anti-suit Apple. This is the procedural shenanigans that went on in the run-up to the licence that we're concerned with. And this is Qualcomm seeking to anti-suit Apple for pursuing foreign claims or starting new ones. And we can see at the state of the litigation, if we pick it up at the bottom of page 187, we see Apple had filed a complaint against Qualcomm. There are allegations of breach of contract, patent claims and antitrust claims. And over the page we see the contract claims are about royalty rebates. Line 4 we see the patent claims related to individual patents said to be not infringed. And line 8, the further argument about unenforceability of individual patents. Line 16 identifies the antitrust claims. That was Apple's claim against Qualcomm. We go on to page 190, we see some of the foreign proceedings that were referred to. So we see the UK action brought by Apple concerned an allegation of breach of Article 102. The top of page 191, we see they were also seeking an order requiring the offering of FRAND licences and claims directed to the validity of 5 individual patents. There were various other claims identified in Japan, China and Taiwan, and Qualcomm was arguing that all of these foreign claims were in fact tied to the contractual FRAND dispute of Qualcomm's FRAND obligations. And we see that at page 195 at around the top whole page. And what was going on in this application, my lords, is Qualcomm tried to argue it was in the same position as arose in the Microsoft and Motorola case. You may recall that's referred to in the Supreme Court on My Planet. And this is the foot of 199 over to the top of page 200. But of course the key difference, key point in the Microsoft case is that the party enjoined, Motorola, was a party who'd made the binding commitment to the standard setting organisation. And you see the judge makes that point here at the top hole on page 200. Whereas it was the opposite here, and we see that being made on the opposite page from about line 13 downwards, the bit that's marked. The point is Apple had not agreed to take any licence and had not committed to Etsy because it was the implementer. But the really key thing for my purpose is footnote 5 at the bottom of page 200. Here you see it very clearly explained that Apple's complaint did not ask for a worldwide FRAND determination. That relief was only found in Qualcomm's counterclaim. Apple didn't ask for it, Qualcomm did. And reading on, we see in the next few lines, Qualcomm was arguing that the court should determine the worldwide FRAND dispute. Look please at line 22. See what the judge explains here became apparent at the oral argument. Apple's position was that the US court didn't have authority to adjudicate Qualcomm's counterclaim for global determination because Apple's under no obligation to accept the offer, regardless of whether it's FRAND, because Apple hadn't consented to be bound by any global determination. And at line 25 they argue that the court, by setting global FRAND, would be an advisory opinion. Whether that last point was right or wrong, we see very clearly set out in this footnote that Qualcomm wanted a global FRAND determination by the US court, but Apple refused. The idea that they were subjected to hold up and agreed super FRAND rates with Qualcomm really bears no scrutiny at all, my lords. Qualcomm was chomping at the bit to get the global FRAND dispute determined by the US court, and Apple was bending over backwards to avoid it. Yet we are supposed to take seriously the suggestion that at the same time, they then went and agreed super FRAND rates because Qualcomm had them over a barrel and secured that higher rate by hold up. My lords, the truth of the matter is absolutely plain, and back in our written submissions in Supplementary Bundle 1, page 80, we deal with that in paragraphs 648 and 649. There was an attempt in closing to put forward an explanation without any evidence at all that Apple had to withdraw the legal claim to have FRAND determined because Qualcomm threatened to withdraw chip supplies. Even if Apple even asked the court to determine the dispute. So quite contrary to what we've just seen recorded in footnote 5. And over the page, we deal with the fact that the FRAND determination sought by Apple was patent by patent. We say bought pursuant to the same holdout strategy we will see as part of their policy tomorrow. And we also point out at the end of paragraph 650 over the page there, that Apple had in fact fought hard to keep a FRAND determination on Qualcomm's portfolio out of the US case. Now please note para 651 and 652 because this is absolutely key. We referred to our suggestion that the reason Apple took the course it did was because even with Qualcomm's differing position, Apple still perceived it could do better in negotiations with Qualcomm than would be the result of a true FRAND determination in court. That is the essence of why they're seeking to keep it out. They think they can do better. And remarkably, my learned friend's attempt to explain this away actually confirms our point. So we set it out verbatim there. My friend confirmed that it was right to suggest Apple was seeking a FRAND determination on a patent-by-patent basis. I would interject, as we'll see tomorrow, that is the blueprint for holdout. And he goes on, Apple didn't like the idea of portfolio approach. And we see that he goes on and explains that Miss Muse thought the portfolio approach was inherently more likely to lead to overvaluation by a decision maker of the patents and insufficient allowance for risk and so forth. That last reference to the top fish in the bucket is a reference to Mr. Nicholson's colourful way of trying to describe licensing portfolios. His idea was that you have a bucket full of rotten fish with a few fresh ones on the top. Not entirely fair, but that's what the reference to the fish is. Now, my lords, as we point out in paragraph 652, my learned friend put this as tactfully as he could, but the reality of this, the reference to decision maker is the US District Court judge, and this is simply saying Apple feared this decision maker would get FRAND wrong in its view, and that's why it wanted a patent by patent approach, as I think I've already alluded to, doing exactly what it wanted to do here in Trial F, saying exactly what I think it said to my Lord Justice Arnold in the Trial F appeal. It's the same reason.
Absolutely. And it's Panasonic and Xiaomi, etc.
Exactly, and it's the absolute badge.
You can't possibly have a court decide it because the court
they get it wrong.
won't give you the right answer.
Exactly. And so paragraph 653 sets out the conclusion. So, my lords, we say the idea that Qualcomm, the deal that Qualcomm did is where Apple felt pressurised that it couldn't have secured an appropriate global FRAND determination is for the birds. In fact, as we say, it is the only Apple license which isn't distorted by Apple's policy of holdout, and we'll be seeing more of that tomorrow. The judge never decided it, and it was this issue, but basically, if he had, there's only one conceivable answer.
Is that going to be a convenient moment?
It is, my lords. I'm just going to move on to ground 7.
Yeah. In which case, 10:30 in the morning.